All right, so let's set the scene. Imagine you're there, national conference, huge room, absolutely packed, standing room only. And everyone's focused on this stage where Louis Lessig is about to start. He is this Esquire, SHRM, SCP, SPHR, lots of letters after his name.
Right. And the session title really grabs you. Defending Your Workplace. Navigating the New Legal Labyrinth of Employment Retaliation.
Exactly. And that's what we're diving into today, the key stuff from that session, because, well, it felt really important.
It really did. And Lessig, he's not just talking theory. He's an employment law litigator, a partner at Brown and Connery in New Jersey. He represents employers all over the country.
Yeah, they call him the employment law translator, which kind of fits, right? He makes this dense legal stuff. Well, makes sense.
Totally. And he's comfortable anywhere, apparently. Jury box, conference, stage.
Yeah.
Doesn't matter. He's a trial attorney through and through.
And get this, the intro mentioned, he's saved clients millions just in the last few years. Plus, he's been a super lawyer for ages since 2012. Won awards. Delaware Valley HR Consultant of the Year, Smart CEO Award.
He's got the credentials for sure.
Yeah.
Deeply involved in SHRM too, former president of the Philly NSA chapter, Camden County Bar.
Oh, and the introducer dropped this fun fact, former chocolatier.
Huh. The chocolatier turned litigator. Okay?
You know, it kind of makes you think, why does someone so deep in the courtroom trenches focus so much on, like, preventing stuff with employers?
That's exactly it. He said his whole mission is helping employers tackle retaliation everywhere, from the boardroom to the courtroom. It's about the bottom line profitability, managing liability, keeping those operating budgets in check. It's what he does day in, day out.
And he jumped right into why it matters so much. Retaliation, he said, is just rampant and incredibly expensive. It hits employers right where it hurts the finances.
Yeah, it's not just like an HR inconvenience. It's a major financial drain. Definitely. And he backed it up with some pretty stark numbers from the EEOC, the Equal Employment Opportunity Commission, for fiscal 2024.
Okay, what did they find?
Well, over 88,000 cases filed in total, which, by the way, was a 20% jump from the year before.
Wow, 20% increase.
Yeah. And the EEOC got back around $700 million for employees.
$700 million. That's a number that gets your attention.
It really should. But here's the real kicker, the part that connects everything.
Yeah.
Retaliation isn't just one type of claim. It is the most common claim.
The most common. More than discrimination itself.
Yep. 52% of all charges filed involved retaliation. Same percentage as the year before, so it's not a blip. It's a huge, consistent problem, right at the top of the list for employers.
Okay, so if it's that big a problem, what actually makes up a retaliation claim? He broke that down, right? The core piece.
He did. 3 essential parts. First, there has to be a protected activity, meaning the employee did something the law protects, like trying to take FMLA leave, filing a charge with the EEOC, complaining about discrimination, maybe asking for a reasonable accommodation under the ADA, things like that.
Got it. So step 1, the employee does something legally protected. What's next?
Step 2 is a material adverse action. And this has to be serious, not just, a manager being grumpy.
Right.
It's got to be something real that negatively impacts their job. Getting fired, demoted, maybe a bad transfer, losing pay, a big change in duties, something that would actually make a reasonable person think twice about complaining again.
Okay, protected activity, adverse action, and the third piece.
The third piece is the causal connection, linking the protected activity to the adverse action. And this is where Lessig said things get really sticky.
Sticky how?
Because often the original thing the employee complained about, maybe it was race discrimination or gender, whatever that initial claim might actually fade away or get dropped. But the company is still on the hook, mainly defending the retaliation part, the claim that they punished the employee for complaining.
So the retaliation claim outlives the original issue sometimes.
Exactly. He said people often file these because they feel like somebody did them wrong in response to their first action. There's this feeling of needing to get back, lots of emotion tied up in it, which makes timing and how things are handled absolutely crucial.
Right. And to make this real, he didn't just stick to the theory. He shared 5 actual case studies, some from his own trials.
Yeah, he said stories really bring the complexities, the sort of gray areas to life. And these were recent cases.
So let's unpack those. What did these courtroom battles show?
Okay, the first one, Anthony's case, Lessig called it by the skin of his teeth. Picture this. CEO suspends the head of rentals for not collecting rent money. Okay, sounds straightforward enough. But just 36 hours before that suspension, the manager had filed a harassment complaint against the CEO.
Oh, boy. Okay, that looks bad.
Right. But here's the twist. The CEO only found out about the complaint after he'd already suspended the manager. And later, other stuff came out about missing copper, missing cash.
So how did the court see it? The timing is so tight.
Well, the employer actually won. They got summary judgment, meaning the case was dismissed before trial. The judge found the investigation into the rent and the missing stuff started before the harassment complaint was even filed. And crucially, the CEO didn't know about the complaint when he made the suspension decision.
Wow. So documentation and proving when the CEO knew was key. Close call, though.
Very close call. It shows how vital that timeline evidence is. Next case was totally different. A university associate general counsel.
Okay.
This person had known mobility and cognitive issues. During COVID, they'd worked out some informal, unwritten deal to work from home. Then the general counsel says, okay, everyone back to the office.
And the associate GC.
She formally requests accommodations. Then, like a week later, has a panic attack at work. She asks for fully remote work for 6 months. Denied. Immediately. And her original accommodation request, also denied.
Oof. That sounds abrupt. How did the court react?
The court denied the university's motion to dismiss. The case went forward. The judge basically said she had completely made her case. Lessig, listening to the facts, even said his reaction was just, General counsel, what were you thinking?
Yeah, seems like a bad move, especially with the prior informal setup. Shows how not to handle accommodation requests.
Definitely. Then there was Miss Heron, the hospital cook. She came back from 12 weeks of FMLA leave.
Okay.
Soon after, she gets written up. Refused to make French toast, even though they had the ingredients.
Yeah.
Apparently discussed another employee's private health info. Admitted she didn't make onion rings because she didn't want to take them out and restock them. Then she was fired.
So she sued, claiming it was because she took FMLA.
Yep, FMLA retaliation.
Yeah.
Her argument was basically, look at the timing, I just got back from leave. But it seems the employer won this one too. The implication was the court didn't find a causal link between the FMLA leave and her firing. The documented performance issues, the policy violations, those were the reasons. Timing alone wasn't enough here.
So having clear, documented, legitimate reasons for the firing, separate from the leave, was critical.
Exactly. Now, the fourth case Lessig shared really highlights the financial danger. This involved a chief people officer at a law firm.
Okay.
She was a longtime employment lawyer herself. During recruiting, she points out to a senior partner, hey, you offered this male associate $85K, but a woman in a similar role only makes $65K.
Uh-oh. How did the partner take that?
Badly. Apparently, he blew up yelling, it's my firm, and then demoted her. From chief people officer down to basically an intake clerk.
Whoa. It's blatant.
Coldly blatant.
Yeah.
Direct response to her raising a potential pay discrimination issue of protected activity.
And the outcome?
The jury found retaliation and awarded her $3.27 million.
3.27 million. Okay.
Yeah.
That number just hammers home the risk. That's a massive hit to any operating budget.
Huge. And it shows how personal reactions from leaders can have enormous consequences. Finally, he talked about one of his own jury trials. He represented the employer.
And the outcome?
No retaliation, the jury decided. This case involved a construction project manager, an African-American woman over 65. She reported a hole in a fence, sent this 8-page letter with photos on official company letterhead, which was against their rules.
Okay, some friction there.
Yeah, definitely fiction. She got pulled from some meetings. Then she's at a conference in a breakout session and just launches into what he called a 3-minute diatribe against her own company, its work, her colleagues, publicly.
Yikes.
Yeah, so she was fired immediately after that. She sued, claiming whistleblowing, race discrimination, age discrimination.
But the jury sided with the employer.
Yeah.
Why?
Lessig pointed out a few things. One, the hole in the fence. It was fixed before OSHA even showed up. Two, the jury just didn't see a connection between her reporting stuff and getting fired. But maybe most importantly, testimony painted her as not a nice boss, not a team player, someone who wasn't listening.
So her own behavior, particularly the public outburst, really undermined her claim.
It seems so. The jury didn't buy the retaliation angle, and her 6-figure demand got tossed out. It shows that even with protected activity, the employee's conduct still matters. A lot.
Okay, so putting all these stories together, the big takeaway for employers is clear. Avoid becoming part of that $700 million the EEOC collects. You need strategies.
Exactly. And Lessig spent the last part of his session on exactly that. Actionable things you can do, like Monday morning, back at your desk.
What were the key steps?
First, big one. Don't assume anything. Don't assume supervisors know the law or how to handle these things. Don't assume employees are always, acting in good faith or won't get emotional. Emotions run super high in these situations.
That seems fundamental. What else?
Second, and this is really interesting, he talked about address civility. He said civility is a real issue now. People are on edge, quick to feel slighted or sad, as he put it.
Huh. So being more civil isn't just nice to have.
Apparently not. He framed it as crucial for diffusing emotions that can lead to retaliation claims. If people feel heard and respected, even when there's conflict or discipline, maybe they're less likely to feel targeted. He even suggested specific civility training.
Interesting. Okay, what's third?
Third is maybe the most classic advice, but clearly vital. Documental, like your organization depended on it. We saw that in the cases, right?
Sure.
Good documentation, accurate timing that saved the employers who won. Lessig feels a lot of younger managers just haven't mastered this. It's a skill gap.
If it's not written down.
It basically didn't happen in court. Yeah.
Right.
Fourth point follows from that. Assess your supervisors and managers. What do they actually know about retaliation? What support or training do they need? Because a poorly trained manager is just, as he put it, a risk waiting to happen.
And standard EEO training isn't enough.
He argued no, not even close. Said most dedicate maybe 5 slides to retaliation, which, given it's the #1 claim, that's nowhere near sufficient.
Makes sense. What was the fifth point?
Review your investigative process. Are your investigators asking the right questions, specifically digging into potential retaliation angles? They can easily miss things. And for smaller companies especially, he strongly recommended considering outside investigators.
To avoid bias.
Exactly, for objectivity. He said, look, it's better to spend a couple shekels now, his words, than end up as part of that $700 million. Puts the cost in perspective.
Definitely. And the last piece of advice.
Connect with your employment counsel. Don't assume your general counsel is an expert in employment law specifically. It's a really specialized, fast-changing area. Getting advice from someone who lives and breathes this stuff is critical for staying profitable and out of court.
So all these steps point towards being proactive, being prepared.
Right, because at the end of the day, Lessig reminded everyone, the most important person isn't the CEO or the employee. It's the jury, or the judge, or the arbitrator. They're the ones who decide what is and what isn't okay. Their perception is reality in these cases.
That's a sobering thought. So wrapping this up, the mission here was really to take those insights from Lessig's session, from someone deep in the trenches, and give you practical ways to protect your organization's bottom line from these really damaging retaliation claims.
Absolutely. It's about managing that risk effectively.
So here's something to chew on. Thinking about Lessig's point on civility and emotion. How can you, in your workplace, build a culture where people feel safe raising concerns, where performance issues can be addressed honestly but without automatically triggering fears of retaliation? What small, maybe even subtle changes in how people interact day to day could actually lower the emotional temperature and ultimately reduce your legal risk? Something to think about.